listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Good to see you, Kyla.
Yes, nice to see you. Still on vacation. Will you ever be back for the podcast?
I'll be back next week for the podcast. I'm looking forward to it. I miss the office. You know, I miss the hustle and bustle of the office. I miss you. I miss everybody there. So no, it's all right. I don't these are things, especially as a parent, that you have to do. You know, I like to work. You know, I have a compulsive problem with needing to work and struggling with forcing myself into downtime. I think this is probably useful for me, but I'm struggling. I want to work.
Yeah, okay. All right. Well, I'm sorry for you. Does people what did I
Because
have?
I'm on vacation.
I know I had a trial continuation on Wednesday, but I can literally not remember what I did on Monday and Tuesday. That's how busy I was. Like, those days are just gone from my
Well,
brain.
I'm sorry that you're that busy, and I know that it increases the workload when I'm away. I did conduct a bunch of hearings, though. I've conducted at least 6 hearings so far this week. I've got one more today.
You don't have any hearings today.
1:00.
No, I'm doing that one. I told you 3 times.
Oh, I thought you told me 6 times that you wanted to go to the PNE this afternoon.
No, I told you 6 times I'm too busy with all the hearings next week that I can't go to the PNE each.
Oh, so you're gonna do it. You're gonna do it. Okay. Oh God, I was all worried. I haven't downloaded the information yet.
Yeah, sorry. I have no choice but to do my job.
Well, thank you. Well, that's good. Okay. Well, I have a project I have to do for you today, which is property maintenance of a property that you happen to own somewhere in central BC that you've never seen. So I'm gonna go do that for you.
I've seen pictures.
For the viewers, about a decade back, Kyla was looking around the province, and anytime she'd see a piece of property that was priced under $20,000, she bought it, which wasn't a lot, but it was enough now that she owns a handful of properties across British Columbia, and she hasn't seen probably most of them.
Like 75% of them, yeah.
Yeah.
I intend to see them. I'm going to see one of them in a couple weeks.
Are you? Oh, good. Yeah. Okay. Well, that one, yes. That one's quite understandable because it's quite a ways out. But some of them were places that you went for trials and got to love the location and thought, oh, I'll be back here for 15 more trials. I can always see my property then, and I'll look forward to coming back and visiting that property that I bought that I've never seen, that I bought after the trial.
I also have like dreams of building like social housing, like those little container housing.
Well, there's very few of the locations where there's that sort of demand. I mean, for that property, a lot of it is rural commercial property. So yeah, anyway, so I'm going to go do some maintenance of one of your rural commercial properties today.
Well, thank you. I appreciate that. All right. This is not the Kyla's weird property investment idea from a decade ago podcast. This is the Driving Law podcast. And there has been, surprisingly, a lot of driving law in the last couple weeks. The first one I want to talk about, Paul, and I didn't actually send you anything about this, so this is kind of a surprise to you. We've been following on the podcast the class action lawsuit against ICBC to essentially recover funds that were paid because of the double dipping. Remember, they were billing MSP for services provided by doctors, but they were also like taking it from the client or something like that, and so ICBC was double billing.
Yeah, they were charging against the person who was at fault, the medical care.
Yeah,
when the medical care is provided by the public health care.
Yep. So that's the class action. And there has been a hiccup in the class action, which of course was certified and we were all excited it was moving forward, but there's been a hiccup.
Yeah. And what is
Very,
that?
very interesting one. I like the creativity, but I don't like ICBC, so I'm not happy about it at the same time. And I also think it's kind of stupid, as far as like this case has been going on since 2020, and this is just like adding another hurdle that's delaying justice while ICBC continues to do this illegal practice.
So what's the hiccup? Is what
The
I
hiccup. The hiccup is the province effectively, so the provincial government saying, "Oh, actually, in the class action, you're asking for all of this material and all of this money related to things like chiropractic, massage therapy, physiotherapy, ambulance services, inpatient and outpatient hospital services,
So not everything is covered by the healthcare.
No, it's all things that are covered under MSP because you can get massage
Okay.
under
Yeah.
MSP if
Okay.
you're
I know.
referred to it, right?
Okay. Yeah.
But it's not services provided by medical practitioners. And the way the class action was framed in the actual pleadings was doctors and medical practitioners, which is just another legal term for doctor.
See, here's the thing about that. I have a couple of points.
Mm.
Number one, the government should not be trying to stymie something on the basis of some technical stupid thing that we all know is just like, and courts have gone both ways on that over the years, and it always seems to me that it almost feels political the way that they go. It doesn't feel like the court is a fair body. It just feels like the court's deciding it on the basis of, from one to the next. I don't like that, but I do admire creativity. And you want to drive while prohibited this week on a technical thing, and you've won the last 7 of them that you've run or whatever it is on some weird technical thing that you found. And I see that in the context of punishing people, that's good that you have those technical defenses. But I'm not enthusiastic about this. But I want to say something else about creativity. There was an article in the Lawyers Weekly or Lawyers Daily or something this week about creativity and talking about inbreeding in law firms and being incapable of thinking out of the box. And I don't see this as creativity. I see this as nitpickery with one of those people who can sit down and look and go, you look here, you didn't dot your I type
So
thing.
governmenty.
So governmenty. So I don't see this as creativity. One of the things that article told me, I mean, it reaffirmed you and I have been, had a 14-year role where we've been able to come up with creative stuff. I would say that we are not as creative as we were, but like nobody's come along and been more so in our realm, in our area. Some of the people that we deal with in the States, because we're dealing with a group of lawyers who are like-minded with us. Yes. But it is a problem in law firms. And we, the self-congratulatory, as I just did, tendency that we have in law firms keeps us from being creative. And creativity has been our superpower for a long time. And we've got to keep it going, rather than falling into this dot your I business.
Yeah, I agree.
That's a little off topic, but
No, it's not. I mean,
something that I've been thinking about a lot lately is like how we stay dynamic, right?
I was actually having this conversation with lawyers Peter Sankoff, whom everyone should subscribe if you were a listener of this podcast that is also a criminal lawyer. Subscribe to the Sankoff CDE services because it's fantastic. But he had a little event at our distillery on Wednesday, and I was talking to some of the lawyers there about like technicalities and the way that technicalities actually work, in law, and how when it comes to impaired driving type cases and driving while prohibited cases, all those little nitpicky dot your I's, cross your T's things are legitimate defenses. But then when you see the government using that type of stuff to perpetuate injustice or to prevent recompense.
A claim from actually being considered on its merits.
Yeah. then it looks like the scales are imbalanced, right? Like when you have an accused person and they're facing a significant consequence, a mandatory minimum penalty with prohibited driving and impaired driving, it makes sense to rely on strict adherence to the rules, because that's for the benefit of somebody who's at a disadvantage relative to the state. Even if they hire, an excellent lawyer and they have tons of financial resources, they're still at a disadvantage relative to the state. But now you have the state essentially acting in concert with ICBC to prevent the government and people who were injured in car accidents from getting money that they should have been paid back.
Yep.
It makes no sense. Anyway, so now what is going to happen as a result of this is
Just feels like the state has their finger on the scale all the
Well,
time.
and let's not forget that the government has historically and continues to pass legislation to prevent certain types of lawsuits once they're unsuccessful or they're annoyed by them.
Yes.
So, yeah. So there number of orders have been made that it's required that the plaintiffs make an application to amend their amended notice of civil claim. They have to then bring that application in court. They have to seek leave for it. And then it must be coupled with a hearing, if they get leave, to either amend the certification order or seek an order that the current form of certification order may remain in effect, notwithstanding any amendment. And then that amendment application is being adjourned to a 4-day hearing where the court's going to consider both together. So now we're looking for 4 days of BC Supreme Court time. Good freaking luck. And
Well, there's a judge assigned. They'll find it. It's not like you or me, regular folks, going in there.
I know, but it takes 4 days of court time away from everybody else.
No, yeah, oh yeah, it takes the 4 days of court time away from our clients who are trying to get in there to conduct a judicial review of an immediate roadside prohibition.
Yep. So anyway, it's a
It's
big
actually shameful service that we get from our court. It's just
no.
pains me.
We don't get shameful service from our court. We have an underfunded, understaffed court that is doing the best it can with the shameful resources that it's given by government.
Yeah, the result is shameful services. You can point the finger higher up and who puts the money in, but I also think it's a lack of creativity.
Well, okay, so yesterday I was supposed to be doing a 2-day judicial review, and we got bumped because there was no judge available. And while we were standing at the registry talking about creativity, the BC Supreme Court has put out a call to the profession for input on anything they can do. Please, lawyers, be creative for us because we're doing the best we can to try and fix the fact that you can't get dates in BC Supreme Court. And so I was talking about with them, like, have you submitted your suggestions yet? And of course, these lawyers on the other side had no idea that this was even going on. And I think didn't give two shits anyway. But, but I was like, because I put in all sorts of crazy creative ones. And they're like, oh, yeah, what'd you suggest? I'm like, weekends in night court. And the poor woman behind the counter was like, no.
Yeah, I mean, to deal with backlogs.
I would come in and argue a case on a Saturday.
Yeah, absolutely. It'd be nice. Nobody in there would feel like less stress if you just have the one off on a Saturday every once in a while.
Yep, a working people who work during the week.
Yeah, absolutely.
Like, I get they're unionized and they don't want to do that, but like you could hire, like you can actually within unions hire like outside people that are outside the union. There's a word for them to do that job on the weekend. So
I often find that
Exactly.
that things that shouldn't require a going and asking a question end up delaying things in the process. So if you're dealing with the registry, there's lots of times that those people are not empowered as much as they should be to guide things along. And you end up in front of a judge and you're standing there and the matter gets adjourned because of some reason or another. And back when I first was early practicing in provincial court, of course, we had JPs in initial appearance rooms, which we do now. But occasionally, we'd have a judge in there, and when things would get backlogged, Judge McGivern used to go sit in courtroom 100, which was our initial appearance room in Main Street Courthouse, and he'd be like getting things done. Judge Gove did that. There was a couple other judges. Carrie Smith did that, but McGivern was the one who would be like, "We have a backlog in this courthouse. We're going to get things cracking here. I want to know what's happening with these files. Put 200 files on the list for I'm going to deal with them." And he would. He'd go through them, and because he was a hardworking public servant, and I just so often I see, just a incapacity to make a decision. He had the power to make the decisions, right?
Paul,
Yes.
I hate to interrupt your story, but we have breaking news on this podcast.
What?
Breaking news, because the BC Court of Appeal decisions come out at 10 o'clock every morning, and I kind of was glancing at them while you were talking about something I've heard you talk before. The dangerous driving case involving the man who ran the red light in downtown Vancouver and killed that baby. The Court of Appeal has issued their reasons, and the Crown appeal from acquittal dismissed with one dissenting justice.
With a dissent, so it can go to the Supreme Court of Canada now. They didn't want to make a decision. They wanted it to make a decision and have it go to the Supreme Court of Canada, so they made one dissent.
Yep.
I'm sorry, that's my cynical view of it, because I don't.
Okay, I want to
approach
talk
these
about this
things.
because this
Tell
is
me about it, yeah.
this is breaking
This
news.
is breaking news. Yeah.
We're reading this at the first time, so I apologize.
This is important for us because, as Kyla reads, I will tell you we've also had a dangerous driving, red light causing death case that we defended, and our client was acquitted. It was complex and painful, and but it was done. And of course, we were relying on this provincial court decision of this case in downtown Vancouver, where this fellow ran through red light. Basically like a bad error in driving. There was only this very short period that it happened, so there wasn't a pattern of driving behavior. And ultimately, he was acquitted of dangerous driving, causing death. And of course, the Crown appealed that, and we had been relying on that decision and lower court decision. And one of the arguments the Crown made in ours was, well, this isn't decided yet, and it's been appealed, and this could be wrong. And so we've been hanging on this for a while, and our big concern has been, and remains to this day, that we see a creep in what is considered dangerous driving. And this was a stop to the creep of what we consider dangerous driving. When one case went to the Supreme Court of Canada where the fellow was speeding on either Cambie or Oak Street, I'm not sure now, in Vancouver, caused an accident, led to the death of a doctor. So bad facts making bad law basically was our concern. And that was the first time in a while that we had seen speed as the thing that constituted the dangerous driving conviction. And of course, that's changed the legal landscape for us because of that. And now we are in a situation where the Crown was looking for expanded, without a pattern of driving behavior, convictions for run a red light, that's dangerous driving. And
Okay, so
this was our concern. So what do we have, Kyla?
So here's what the Court of Appeal says about that. The Crown essentially focused their argument, first of all, on this one passage. And when we were arguing our case, this was something the Crown also really, they must have obviously read the factum, because they were pointing out that in the trial judge's reasons, she cited a passage from the Supreme Court of Canada's decision in BT that was from a concurring judgment, not the majority judgment, and she incorrectly attributed it to the majority judgment. And the Court of Appeal says, yeah, she did incorrectly attribute it to the majority when it wasn't, but she didn't actually apply the law the trial judge didn't actually apply the law incorrectly. And the court says in paragraph 33 of the Court of Appeal decision, The observation that in practical terms a momentary lapse in attention without more will generally be insufficient to establish the mens rea for dangerous driving must not be used as a shortcut around the proper application of the modified objective test for the mens rea first articulated in Handel and subsequently affirmed in Beattie, Roy, and Chung. It would be an error of law for a judge to rely on such a categorical rule, thereby failing to give full consideration to the totality of circumstances, bearing upon whether the conduct in issue rises to the level of a marked departure from the standard of care. To put it another way, a trial judge may fall into legal error by fixating on the categorization of the driving conduct as momentary in a manner that short-circuits a case-specific assessment of the totality of the circumstances. And they say this is exactly what happened in Chung. So this is actually a great decision because it reels in that creep that you're concerned about. It reels in them saying, well, any type of momentary lapse of attention could be dangerous driving. It goes back to, no, you still got to assess the totality of the evidence to ask whether this is truly a momentary lapse in attention or whether this is a marked departure. And the court goes on to say that paragraph 41, I think in our case as well, the trial judge relied on this automatic and reflexive nature of driving. That, driving is kind of like this thing that you ever drive.
That's half our submissions.
Ever drive somewhere and you don't even remember how you got there when you arrived? You're like, shit, I wasn't paying much attention today.
Your brain was working. It's just
It says the Crown further contends that the trial judge erred by fixating on what she found to be the respondent's momentary lapse, when the nature of driving as an activity that is sometimes reflexive or automatic has been recognized as part of the rationale for adopting an objective fault element for the offense of dangerous driving. However, the reality that drivers sometimes operate their vehicles without a great deal of conscious thought is a factor that cuts both ways. On the one hand, it would be a denial of common sense for a driver whose conduct was objectively dangerous to be acquitted on the ground that he was not thinking of his manner of driving. On the other hand, the case law recognizes that even the most prudent driver will, from time to time, experience momentary lapses in attention or judgment, and for this reason, criminal liability will only be appropriate where the driving conduct in issue rises to the level of a marked departure from the standard of care that a reasonable person would observe in the circumstances. Momentary lapses in attention or judgment are not assessed differently from other driving that poses a danger to the public because conduct that occurs over a brief period of time and which creates foreseeable and immediate risks of serious consequences can still be a marked departure from the norm. And there was no failure by the trial judge to appreciate that. So again, I think it's reeling things back. Now, the court also deals with the Crown.
Is it because we struggle with the same reasonable person test that the Crown always approaches from an unreasonable position? Is this going to actually reduce the number of these cases that we have? I don't know.
I hope so.
I think we're going to end up having to argue more of them on the basis of the way that you're describing it here. I think the test has become too fluid.
No, I think you have to look at the totality of the circumstances and you have to say, like, does this reveal that this is just somebody who just forgot to pay attention momentarily? Or is this somebody who was driving badly and careless or reckless about their manner of operation of the vehicle? Were they not paying attention effectively deliberately?
Okay. Well, okay. But that puts you in a position where you almost always have to put your client on the witness stand.
Or in a position where you can point to an absence of evidence from the Crown, like where you just have, like in Chung, the couple seconds before the accident, but the appreciable conduct was deliberately speeding up into a busy intersection. That was not a momentary lapse of attention. It was deliberate conduct. Whereas this case and ours, just not seeing the red
Not
light.
deliberate conduct. That's true. Yeah.
Yeah, just
Okay.
didn't see the red light. No explanation for it. No evidence of anybody speeding up to try and beat the light, right? Speeding up to beat the light, dangerous driving. Not speeding up to beat the light and just not seeing it, not dangerous driving. It's my view. Anyway.
I kill a mosquito. Yes. Sorry, I got one in here that's attacking me. Okay.
they
Well, that's
all-
exciting news.
Yeah, they also reject the Crown's argument that the judge failed to apply the correct legal test, and that she did engage in the sort of two-step inquiry of whether, in light of all of the relevant evidence, a reasonable person would have foreseen the risk and taken steps to avoid it if possible, and whether the failure to see it and take steps was a marked departure. And that's really the modified objective test. So now we have a really nice summation of the test from our Court of Appeal in a very simple format, which I like. And they reject the persuasiveness of the Crown's submission that the trial judge improperly discounted visual cues that ought to have alerted the accused to the upcoming red light. The fact that there were 4 separate traffic lights, all showing red for some 20 seconds before he entered the intersection, the fact that there were pedestrians in the crosswalk, the fact that the silver hatchback in tandem with his vehicle slowed and stopped while his SUV continued towards the intersection. And the court finds this not persuasive, and I love this because how many times have we seen in
There's
dangerous
4
driving?
lights. It's not just
There's-
one light. There's 4 lights.
There's 3 vehicles stopped. There's, you would have seen the people in the crosswalk.
Yeah.
Um,
There's 2
and
vehicles stopped, and you're in the middle lane, and you assume that somebody's turning right, or that the vehicles are stopped or turning left. That's why you have an open lane.
yeah, and the court basically says, nah, you're trying to reweigh the facts, which Crown is not allowed to do on an appeal, because they're only allowed to appeal from a question of law. So there you go. Now, the dissent.
Rarely does that work in our favor, in the favor of the defense. Anyway.
The dissent from Justice Willock says that he agrees with his colleague Justice Riley that the trial judge erred in expressing the view that a momentary lapse of attention cannot establish mens rea of the offense of dangerous driving without more. But he disagrees that the judgment was not tainted by that error because the error was allegedly repeated and had a material bearing on the outcome.
I don't disagree with that. I mean, I still think that was the correct statement of law, just because it's not the correct statement of law from Chong. Anyway,
it's not the correct statement of law. It's not the law that
I think it's a correct statement of reality. I think it's a correct statement of reality.
Yeah, but I mean, you can have momentary attention that can be dangerous driving. We've seen it in our files.
Oh yeah,
going into the wrong lane, right? The oncoming lane of traffic. Anyway, so this is great.
But sometimes your brain just fails for a minute. Sometimes your brain just fails. We know it. Sometimes your brain just isn't working at all. Sometimes you can have a complete disconnect in your brain, and it can be rare, infrequent, and cause something. And usually it's momentary. And that in itself should be telling you something about the mens rea component of it. Anyway.
Absolutely. Anyway, crazy breaking news here on the podcast today. I'm glad I wasn't paying attention to you.
Thanks a lot. Well, had we not, usually we're aiming for 30 minutes for the podcast, and had we not started late, you wouldn't have got this.
Yeah, so that's great.
I guess our 7 other topics are going to have to go to next week.
Our 7 other topics are going to have to go to next week, but we do still need time to talk about our ridiculous driver of the week.
I'm wondering who you're going to choose.
This one is just bad. It's just bad. Actually, can I say I had a whole joke built up using the lines of the song Photograph by Nickelback to talk about a roadblock after a Nickelback concert, which was one of our original topics. So I'm sorry, listeners, that you don't get to hear my awesome joke. But
well, the RCMP made a joke about it too, so I don't know.
Oh, okay. Well,
they posted their press release said, "Look at this photograph," and it was a picture of an ASD. And
yeah, okay, all right, fine. Then it wouldn't have been fun anyway.
Yeah.
No, this is a BC junk removal company that has been caught on camera with one of its dump trucks dumping
by a different BC junk removal company.
Yeah. Yeah, so it's Dev's Disposals sees Junk Be Gone dumping waste and hazardous material into the bushes. From
so caught on camera, the ridiculous dumper of the week. The Junk Be Gone came out and said, this is not what we do. This is not our policy. This is not our shtick. We fired this person. This was not something that was ever authorized, but this is the second time in a couple of months where we've had somebody in the Lower Mainland caught dumping junk. There was this fellow who was dumping a mattress in his Dodge truck, and the plate was there, and you could easily identify him. He was, I think he may have been our ridiculous dumper of the week a few weeks back, or one we debated having. And now we've got this, and yeah, in the middle of the day, stopping and dumping stuff in the woods.
Yep.
Sometimes you wonder how that junk ended up in the woods. Anyway, paying a fine, I guess.
Yeah, well, apparently he says, the owner of the company says they don't endorse the illegal dumping of the things, and the employee took the truck without permission and dumped things in the woods without permission, and they've been fired. I struggle to believe that an employee would just take a company dump truck and fill it and dump things in the woods when you could just add it to a customer's order and dump it in the course of your employment, like if you were trying to do your personal dumping.
Yeah, I mean, look, employees do rogue things often, and you can't control what people do, and you give them some authorization, give them a set of keys for a truck. There was one of those junk removal companies used to park their trucks up and down 4th in Vancouver, and they'd be sitting there over the weekend. Sometimes it would be gone for a while over the weekend. You never knew if one of those employees had taken those trucks. You would think those guys would have GPS tracking in their trucks by this point, to be able to confirm that something like this doesn't happen. But it's unfortunate that this is where we are in society, and probably always has been, and maybe it just doesn't always come out. But some employees go rogue, and some people are assholes, and it's hard for us to wrap our minds around it. As you were just saying, you have trouble believing the line. You know, we are not mentally prepared to deal with those extreme outliers like that, but unfortunately they're there.
Yeah,
uh,
that's true.
you and I, through the course of our lives, because of our particular occupation, have to deal with some people who are like narcissistic psychopaths. And every time you have to recalibrate your thinking and remember, okay, I'm dealing with a narcissistic psychopath, and but most of us are just going to end up being, and we've been victimized, but that happens. So yeah, you never know. You can't control what people are going to do. People do stupid things.
Yep.
That's the ridiculous dumper of the week, though, for sure.
Ridiculous Trumper of the Week gives me a completely different visual, and I'm going to leave it at that. That's our podcast now. Have that visual in your head too. If you need to find us for any type of driving related incident, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.